For while civil law is the world's most ubiquitous system, the common law and, to a lesser extent, religious and customary law, are applied in a number of countries. Civil law, common law, customary law, religious law, common and civil law. 13. Law's roots. Across the country, with 50 states with different laws, uniformity in respect of commercial transactions is obviously vital. Imagine the confusion in the absence of such standardization. You live in New York and buy a car in New Jersey that is made in Michigan, warehoused in Maine, and delivered to your home. Second, the common law is casuistic. The building blocks are cases rather than, as in the civil law system, texts. Ask any American, Australian, or Antiguan law student how most of his or her study time is spent. The answer will almost certainly be reading cases. Question their counterparts from Argentina, Austria, or Algeria, and they will allude to the civil and penal codes they persistently peruse. The consequence of the common lawyer's preoccupation with what the judges say, rather than what the codes declare, is a more pragmatic, less theoretical approach to legal problem solving. Third, in view of the centrality of court decisions, the common law elevates the doctrine of precedent to a supreme position in the legal system. This doctrine means both that previous decisions of courts that involve substantially similar facts ought to govern present cases, and that the judgments of higher courts are binding on those lower in the judicial hierarchy. The justification for the idea is that it engenders constancy, predictability, and objectivity, while allowing for judges to distinguish apparently binding precedents on the ground that the case before them differs from them in some material respect. A fourth generalization is that while the common law proceeds from the premise where there is a remedy, there is a right, the civil law tradition generally adopts the opposite position: where there is a right, there is a remedy. If the common law is essentially remedial, rather than rights-based, in its outlook, this is plainly a result of the so-called writ system, under which, from the 12th century in England, litigation could not commence without a writ issued on the authority of the king. Every claim had its own. 14. Law. Formal writ. So, for example, the writ of debt was a prerequisite to any action to recover money owing, and the writ of right existed to recover land. In the 17th century, the writ of habeas corpus, literally you must produce the body, was a vital check on arbitrary power, for it required the production of a person detained without trial to be brought before a court. In the absence of a legal justification for his imprisonment, the judge could order the individual to be liberated. It took a century for civil law jurisdictions to accept this fundamental attribute of a free society. Finally, in the 13th century, the common law introduced trial by jury for both criminal and civil cases. The jury decides on the facts of the case, the judge determines the law. Trial by jury has remained a fundamental feature of the common law. This separation between facts and law was never adopted by civil law systems. It illustrates also the importance of the oral tradition of common law as against the essential role of written argument employed by the civil law. The common law, chaos, and codification. Life might be much simpler if the common law consisted of a code of rules, identifiable by reference to source rules, but the reality of the matter is that it is all much more chaotic than that, and the only way to make the common law conform to the ideal would be to codify the system, which would then cease to be common law at all. The myth, for that is what it is, owes its attractiveness to another ideal, that of the rule of law, not men. It consequently distorts the nature of the system to conceive of the common law as a set of rules, an essentially precise notion, as if one could in principle both state the rules of the common law and count them like so many sheep, or engrave them on tablets of stone. A. W. B. Simpson, The Common Law and Legal Theory, in William Twining, ed., Legal Theory and Common Law, Blackwell, 1986, pages 15 to 16. 15. Law's roots. There are also certain jurisdictions, such as Scotland, that, though their legal systems are not codified, preserve varying degrees of Roman INF allegiance. On the other hand, some jurisdictions have avoided the impact of Roman law, but because of the prominence of legislation, these systems resemble the civil law tradition. They include Scandinavian countries, which inhabit an unusual place in the Romano-Germanic family. Other legal traditions. Religious law. No legal system can be properly understood without investigating its religious roots. These roots are often both deep and durable. Indeed, the Roman Catholic Church has the longest, continuously operating legal system in the Western world. The INF allegiance of religion is palpable in the case of Western legal systems. Basic institutions, concepts, and values have their sources in religious rituals, liturgies, and doctrines of the 11th and 12th centuries, reflecting new attitudes toward death, sin, punishment, forgiveness, and salvation, as well as new assumptions concerning the relationship of the divine to the human and of faith to reason. In Europe in the 12th century, ecclesiastical law played an important role in a number of fields. Ecclesiastical courts claimed jurisdiction over a wide range of matters, including heresy, fornication, homosexuality, adultery, defamation, and perjury. Canon law still governs several churches, especially the Roman Catholic Church, the Eastern Orthodox Church, and the Anglican Communion of Churches. The rise of secularism has not completely extinguished the impact of religious law. The jurisdiction of Western legislatures and courts over exclusively religious matters is frequently curtailed, and many legal systems incorporate religious law or delegate to. 16. Law. Religious institutions. Matters of a domestic nature. Nevertheless, one of the hallmarks of Western legality is the separation between church and state. While a number of prominent religious legal traditions coexist with state systems of law, some have actually been adopted as state law. The most significant are Talmudic, Islamic, and Hindu law. All three derive their authority from a divine source, the exposition of religious doctrine as revealed in the Talmud, Quran, and Vedas respectively. Talmudic law. The Talmud represents a brilliant intellectual concept, a book of law which contains endless differences of opinion from all ages and dealing with all that had gone on before, while seen as never definitely finished and thus leaving room for still more opinion, as each age engages with it. There is no equivalent to it in any legal tradition. H. Patrick Glenn, On Common Laws, OUP, 2005, p. 131. Hindu law. Hindu law recognizes the possibility of change, both of law and the world, but it just tolerates it, without in any way encouraging it, as something that's going to happen, but which shouldn't disturb the basic harmony of the world. If it does, it's bad karma, and this too will be dealt with. Thus, for a written tradition, Hindu tradition is incredibly roomy. Toleration is not at the perimeter of it, but at the center. And toleration turns out to have its own kind of discipline. H. Patrick Glenn, Legal Traditions of the World, 2nd ed., OUP, 2004, p. 287. 17. Law's roots. All have INF allegiance secular law in a variety of ways. For example, Talmudic law had a significant impact on Western commercial, civil, and criminal law. In addition to common and civil law systems, it is possible to identify 4 other significant legal traditions. Islamic law, or the Sharia, is based largely on the teachings of the Quran. It extends to all aspects of life, not merely those that pertain to the state or society. It is observed by more than 1/5 of the population of the world, some 1.3 billion people. At its core, Hinduism postulates the notion of karma, goodness and evil on earth determine the nature of one's next existence. Hindu law, especially in relation to family law and succession, applies to around 900 million individuals, mostly living in India. Islamic law. Islamic law seeks constancy with common sense assumptions about humanity, not through the refinement of categories of its own creation. It is a system of adjudication, of ethics, and of logic that finds its touchstone not in the perfecting of doctrine, but in the standards of everyday life, and measured in this way it is enormously developed, integrated, logical and successful. Man's duty is to conform to God's moral limits, not to try to invent them. But within these limits established by God one can create relationships and traffic in the knowledge of their existence, intricacies, and repercussions. Lawrence Rosen, The Anthropology of Justice, Law as Culture in Islamic Society, Cup, 1989, p. 56, quoted in Malis Ruthven, Islam, A Very Short Introduction, OUP, 1997, p. 89. 18. Law. Customary law. To constitute custom, the practices involved require something beyond mere usage or habit. They need to have a degree of legality. This is not always easy to discern, though customary law continues to play an important role, especially in jurisdictions with mixed legal systems such as occur in several African countries. The tenacity of custom is evident also in India and China. Indeed, in respect of the latter, the basic law of the Special Administrative Region of Hong Kong provides that customary law, as part of the laws previously in force in Hong Kong, prior to July 1, 1997, shall be maintained. Mixed legal systems. In some jurisdictions two or more systems interact. In South Africa, for example, the existence of Roman Dutch law is a consequence of the influence of Dutch jurists who drew on Roman law in their writing. This tradition was exported to the Cape Colony in the 17th and 18th centuries. The hybrid nature of South Africa's legal system is especially vivid, since, following the arrival of English common law in the 19th century, the two systems coexisted in a remarkable exercise of legal harmony. And they continue to do so. Like a jewel in a brooch, the Roman Dutch law in South Africa today glitters in a setting that was made in England. Even if it were true, which it is not, that the whole of South African private law and criminal law had remained pure Roman Dutch law, the South African legal system as a whole would still be a hybrid one, in which civil and common law elements jostle with each other. The mixture is no longer nearly as effective in Sri Lanka or Guyana, to where Roman Dutch law was exported in 1799 and 1803 respectively, but where the common law now predominates.